Again, good morning. Welcome to today's webinar hosted by the Texas Council on Family Violence. We're grateful to have each of you join us in this important discussion that's centered on the Federal Domestic Violence Firearms Initiative and its critical role in addressing domestic violence. I'm Gloria Aguilera Terry. I have the privilege to serve as CEO of the Texas Council on Family Violence, and I'll be guiding parts of today's session. Our collective hope is that you are joining from a warm, comfortable location, escaping the cold. In the event that the weather disrupts this live webinar, our friends at SunWest Communications have developed a contingency plan with a backup link. This webinar is also being recorded and will be shared after the event. For those advocates that may be providing direct services at this precise moment and you've taken time away to join the webinar, thank you for putting your own health and safety aside to be able to serve the people that we do. Lastly, we will have a Q&A session in the latter part of the webinar. So as we're going through this, please feel free to think of what those questions might be, and we'll open that up at a time and give you advance notice. So the Texas Council on Family Violence exists to create safer communities and provide unwavering support to survivors of domestic violence. We firmly believe that addressing the intersections of federal law, firearms, and domestic violence is pivotal to advancing justice and safety for victims and survivors. Today's webinar is a testament to the Council's ongoing commitment to bringing together experts, practitioners, and advocates to share insights and foster collaborative solutions. Each segment of this webinar will equip you with practical knowledge and tools to enhance your efforts in addressing the complex dynamics of domestic violence and firearm-related offenses. We hope you leave this webinar with actionable steps, insights, and strengthened resolve to continue making a difference in the lives of survivors. So why are we doing this? Why is TCFV doing this? Because we acknowledge, one, that the presence of a firearm in domestic violence situations increases the risk of homicide to women by 500%. So we sit on that and we use that as a bedrock to drive our work forward. Also, for over a decade now, we've been documenting in the Honoring Texas Victims report, and in last year's report, once again, we identified that 70% of intimate partner homicides were killed with where the victim was killed with a firearm. We know that all of these homicides are knowable, preventable, and that is our role here today. We are deeply honored to have with us today U.S. Attorney Leah Simonton, who will lead her expertise and leadership in this critical conversation. USA Simonton has a remarkable career that exemplifies her dedication to justice and her commitment to combating domestic violence through legal and systemic avenues. She has served with distinction as a U.S. attorney, and I want to purposely highlight for you that she went from intern to the U.S. attorney in her 2-decade tenure. That is quite impressive. USA Simonton has led impactful initiatives and earned immense respect, not only from the legal community, but also here at the Texas Council on Family Violence. Allow me to just name a couple of things that she and her office have been responsible for. The office has tried the highest number of cases in over a decade. She directly supervised high-profile jury cases, and I'll give you a couple of examples. Dr. Reynaldo Ortiz, convicted of injecting heart-stopping drugs into IV bags. Also under her leadership, the appellate division persuaded the Fifth Circuit to affirm the life sentence of a Michigan man who had stalked, transported, and sexually assaulted a 14-year-old girl. Her caseload varies from white-collar crime to violent crime, like the cases I just described. And I could go on and on, but sufficient to say we are indeed privileged to have her insights as part of today's program. U.S.A. Simonton, you also oversaw the progress on a little thing we call the U.S. versus Rahimi case, from the Fifth Circuit all the way to the Supreme Court. So I welcome you to the stage, Leah. And in that vein, I have a couple of questions for you to get us started. In the case of United States versus Rahimi, which made national news when the Supreme Court held that the statute criminalizing the possession of a firearm when someone is under a domestic violence protection order was constitutional under the Second Amendment. That case is from your district. Could you explain the origins of that case?
Thank you so much, Gloria. I want to start by just expressing my office's gratitude to you. You have been an incredible partner during the time I've been U.S. Attorney, and I have to give a shout out to our mutual friend, Jaime Esparza, U.S. Attorney of the Western District of Texas, who put us into contact because he's been doing this work at the state and now the federal level for a long time. So thank you so much for your partnership. And I love that this is the second time we've been able to do this webinar, and that we've also done press conferences to honor Texas domestic violence victims. We are very proud of Rahimi. We are very proud that we were able to prosecute Mr. Rahimi, and that eventually the Supreme Court was able to reestablish his conviction and sentence, and that he is serving time now in federal prison for violating a protective order and having a gun. So the origin of the case speaks to a special initiative that we had in our district. It started in the late 20-teens, and it was created by our predecessor, U.S. Attorney Erin Neely Cox. She and I actually worked on a case that had the same charge that Mr. Rahimi was charged with. And it's a special federal law that prohibits someone who's under a domestic violence protective order from having a gun. And that's when she and I kind of first discovered that law. Someone had charged it, and it's actually a very tricky charge, not for the reasons that it was under Mr. Rahimi's case, but for different reasons, and that were not, thankfully at issue in the Supreme Court case. But through that, she and I realized what a powerful tool it was. And so she created something called the Domestic Violence Initiative in our district. And she wanted our office to focus on cases involving domestic violence abusers who could be brought to justice in our system through typically a firearms charge, but also other types of charges like cyber stalking. And Mr. Rahimi was one of the first people who was prosecuted through that program. It was an amazing AUSA in Fort Worth named Frank Gatto. I'm going to give a shout out to him. He's very knowledgeable in firearms laws. And he was talking to the ATF in the Arlington Police Department about a man named Zaki Rahimi, who was a terror in the Arlington area. And the main way in which he was a terror is that he was threatening women with guns, including his domestic partner and mother of his child. And that woman very bravely got a protective order against him, which is something that I know we wish more women would feel comfortable doing, but they are so scared. So it got so bad with her, and with threats against her child also, that she got a protective order, which he did not dispute. And then he violated the protective order. And then he also used a gun, threatened another woman with a gun. And then he would just threaten random strangers with guns. So the law enforcement figured all of this out, and they brought it to our office. And our prosecutor said, we target cases like this for federal prosecution. Let's charge Mr. Rahimi. And the district court accepted, right? Mr. Rahimi pled guilty. He did not even have a good defense to the charge. And the district court found his conduct was very, very serious and sentenced him to 72 months in prison. Mr. Rahimi on appeal argued that recent Supreme Court law, there's a big case called Bruin, that it had changed the landscape of how the Second Amendment is analyzed for purposes of what laws are constitutional under the Second Amendment. And I will say, a lot of courts are trying to figure out the meaning of Bruin right now. So the Fifth Circuit decided that this conviction and this charge that we brought was unconstitutional under the Supreme Court's current reading of the Second Amendment law. Well, we vigorously wanted the Attorney General and Solicitor General to take that to the Supreme Court, and they felt the exact same way. So they took the issue to the Supreme Court, which accepted it, and I got to attend the argument, which was a huge privilege as a guest of the Solicitor General, who is an incredible advocate, Elizabeth Preliger. She is a star in the appellate world, and she argued this case magnificently. And the Supreme Court held 8-1 that the law was constitutional. I know all of us in both law enforcement areas and in domestic violence areas were holding our breath during this time, because we thought, what is this acceptable to be able to have a gun when you have, I mean, that's basically the question. Is it acceptable to have a gun when you're under a protective order? And thankfully, the Supreme Court held, no, you cannot interpret the Second Amendment as allowing that, as protecting a gun possession in that circumstance. So we have gone ahead and we're using that charge again. Mr. Rahimi is serving his federal sentence, and all is right with the world.
Something I learned from listening to you, Leah, in prior sessions was that the Rahimi case was not an accident. You were deliberately looking for a case, right?
Yes, we looked for, in general, in our office, we look for cases where there are violent people who need to be incapacitated through the federal system, through being put in federal prison for a long time. And we were specifically focusing as one part of that on domestic violence offenders. And we have prosecutors throughout our district who specifically look for those cases. They talk to the ATF about those cases. They talk to DA's offices about those cases so that they can become aware when there are facts that fit into that type of framework that we would be able to charge federally.
Okay. And Leah, I have one more question for you. So what is the impact to the practices of U.S. Attorney's Office? What is the impact of this ruling?
It's huge. It's absolutely huge, because not only did it give us permission to keep charging that, but it brought attention to the fact that we have this tool in our federal toolbox. So I actually think you'll see a lot more prosecutions under that statute than you would have if the Supreme Court had not taken that case, because now it's just well known amongst all the U.S. Attorney's offices and Main Justice that this is something we can use to incapacitate domestic abusers. So based on that, for example, I held a panel at the last U.S. Attorney's Conference that was focused on the post-Rahimi landscape. It was similar to what we're talking about here today. And it was for all the U.S. attorneys across the entire country, which is 93 U.S. attorneys. And then I created a written toolkit, and with some other partners and other offices who are doing amazing work like this. And it had even, sample indictments. It had how to think about, checking some boxes legally to make sure you can charge something and it'll get affirmed on appeal. And I sent that to all the other offices. So everyone was really excited about that in the U.S. Attorney's Office community. And I expect to see a lot more domestic violence programs like ours and charges coming out of the Rahimi case.
Leah, your, the strength of your expertise, the power of your voice, and then all these intellectual components that you already own have left fingerprints across the country. Sometimes saying it simply is best. Thank you. On behalf of the Texas Council, board, staff, member agencies, and especially on behalf of survivors. So thank you.
Thank you.
I'm turning it over to you. My time is up, but thank you, Leah.
Thank you, Gloria. It's a bittersweet time for me because I will be ending my time as U.S. Attorney very soon. In a week and a half, I'm stepping down. But I will be continuing my work in the domestic violence context, and I'm very excited to continue working with amazing organizations like Gloria's and like all of yours who are watching. And I hope to use my knowledge about all the federal sort of legal frameworks at issue here to help facilitate more victims being able to have cases brought against their abusers in the federal system. So with that, I want to introduce my team who is on this webinar today and say how grateful I am for the work that they do. You'll be hearing from three members of the U.S. Attorney's Office. We have Keith Robinson, who is the chief of our violent crimes section in Dallas. And to give a big shout out to Keith, he is another architect of this program. He helps run this program along with an amazing AUSA in our office, John Boyle, who does a lot of the enforcement side in terms of talking with the Dallas DA's office to talk about what cases we can bring under this framework in our Dallas area. And we have brought probably about 200 cases just in the last few years against domestic violence offenders using a lot of our different federal tools. So Keith oversees all of that, and he is extremely well versed in this law and very passionate about it. You will also be hearing from Ted Hochter. Ted is one of our newer AUSAs who is fantastic. Ted has always had a passion for helping victims. That was something that he made clear to me when he interviewed for a job in our office. And he is currently in our national security and cybercrime section, but he also moonlights in other cases, including in the violent crimes context. And he's going to specifically talk about a case that he handled so that you can learn about another way in which we incapacitate domestic abusers. And that's if they violate their supervised release in one of their other federal cases because they have committed a domestic violence offense, and what happens when that person abuses their partner and has to be brought back into federal court because they've basically violated what you would think of as their probation. And the third member of our team is John Bradshaw, Special Litigation Counsel for our office. John is incredible. He helped set up this webinar with Gloria. He does a lot of outreach with our law enforcement partners and our community organizations. John is also passionate about violent crime. He is in our appellate division. So he's someone like me who helps people figure out the legal way for us to do all of this. And he is a specialist in that case I mentioned earlier, Bruin, which was the first case that the Supreme Court had released in quite a while, dealing with how to interpret the Second Amendment. And he helps navigate that legal framework in terms of all of our gun cases in the district. So with that, I'm going to turn it over to Keith Robinson, who will talk about our domestic violence project in our district, since he is one of the heads of that. Thank you, Keith.
Thank you, Leah. First of all, again, my name is Keith Robinson. I am the chief of the violent crimes section in the Dallas office of the United States Attorney's Office for the Northern District of Texas. Shout out first to Leah. She has been such a great advocate and a backer of this program. And I think we've really made an impact in the community. I'll go through kind of what I feel like our success tools have been and how we're going and where we're going in the future. As Leah said, back really late, teens, 2018, 19, 20, we really kind of got this program up and running. Basically, to address the problem of domestic violence in our community and in the United States too, the U.S. Attorney's Office created this domestic violence initiative. The initiative, quite frankly, is based on keeping firearms out of the hands of domestic abusers by using the tools of federal prosecution. And history shows us, as Gloria mentioned and Leah, that gun violence and domestic violence are intertwined, that offenders with domestic violence in their past pose a remarkably high risk of homicide. So, as I said earlier, research shows that there is that correlation. Some of these stats were mentioned earlier, but I pulled some more recent ones from the last time I talked to y'all. Among homicides in the United States, intimate partners kill almost 50% of female and 10% of male victims. And bringing that a little bit closer to home, In Texas, domestic violence homicides have almost doubled in the last 10 years. In Texas, in 2023, I think that's the last reporting period. I don't think 2024 is out yet, but 205 people were killed by their intimate partners. About 1 in 5 of those victims were here in North Texas alone. And firearms were the leading cause of death. So breaking that down a little bit further, and Gloria mentioned this earlier, research shows that abusers with a gun in the home are 5 times more likely to kill their partners than abusers who don't have that same access to a gun. That also means that the mere presence of a gun increases the risk of homicide by 500%. Just a different way of saying that. But when we started looking at these numbers, we thought to ourselves, how can we help? What can we do to enter the fight? And that's where, excuse me, I'm getting my screen corrected here. That's where we kind of looked at, fighting our domestic violence issues in our community with the strength of our federal firearms laws. Because of the gun connection and the violence connection, that's where we first started out. And I'm going to go through these. Everybody has a role. We at the U.S. Attorney's Office realize that it's our state and local partners. When I say that, I mean our DA's offices, our police departments. They are passionate about combating domestic violence. We rely on them, quite frankly, to do most of the heavy lifting surrounding family violence disputes. But as we looked at it as an office, again, we asked, how could we help? And I think what brought to light is we started meeting with the DA's office. We started meeting with our federal agents and agencies and talking to our local police departments and basically all the stakeholders. And it became clear that we did have these federal firearms laws in our tool bag to help with this problem. So everybody has a role. First, I think just by way of background, just to show you geographically, these are the different districts in the state of Texas. So in the red area is the Northern District of Texas. So geographically, we're huge. Right there, you can see kind of a blow up of what the area of responsibility for the Northern District of Texas. So this was a big project. We really got it off the ground here in Dallas, and then we started going into Fort Worth at the same time. And then we have our programs in Lubbock and Amarillo and out in San Angelo. But so you could see, geographically, we had a big area, and we needed to implement this program in a meaningful way. And so what I'd like to do at this point is kind of go over, what our tools for success, what I have seen makes this program work. Number one, it's our partnership with our state and local law enforcement. And again, I include the DA's offices and the local police departments and our federal also agents, but also enforcing the existing firearm statutes. I mean, how many times do we hear, well, we got to have a new law or this or that? Well, we have statutes that exist that if we use them, we can make a difference. So with regard to the partnerships, Leah mentioned this earlier. We have task force officers. They're basically local police officers who are sworn in at the federal level to help prosecute federal cases. And we have special agents, which are just your normal agents, but they're embedded at our local police departments. And they do a great job identifying domestic violence abusers who possess firearms. So they're actually there. They're screening those cases at the point where they're going to be submitted to our local DA's offices. And they can tag those cases for us and bring those to our attention. We also have, at a different angle, we have AUSAs working with our local DAs to identify firearms offenses, including those involving domestic violence abusers. And again, there's a screening process for that. For example, I'll talk about Dallas, and the different offices may have a slightly different variation of this, but I think it's mainly the same. We have an AUSA who goes over to our Dallas County District Attorney's office either weekly or biweekly. And they have, in advance of that, tagged certain cases that might, they feel like, would be either impactful and that might fit our program. And so I have an AUSA who goes over and he looks at all those cases, like I said, on a weekly or biweekly basis. Do they meet the criteria of our program? Can we bring a federal charge? And we look through those. So again, we're attacking it at the local level, like before it even gets to the DA's office. And those agents or task force officers will bring it to our attention. And if something slips through at that level, we're also having the DA's office and one of our AUSAs go over there and see, again, if there are cases that would meet our initiative. So the second part of that, in addition to our partnerships, I said enforcing existing federal statutes. These three statutes here are our main arsenal. These are firearm statutes. They're all under 18 United States Code, Section 922, and they're just the different provisions: G1s, G8s, and G9s. For some time, federal laws prohibited domestic violence abusers from possessing firearms. That includes men and women convicted of either felony or misdemeanor crimes of domestic violence, as well as those subject to certain protective orders. And I'm going to kind of go through these. I think it's good to have an understanding of the different statutes and what we need to prove those. 18 USC 922 G1 is possession of a firearm by a person who's been convicted of a felony offense. That's, you're felon in possession of a firearm, simply put. G8, next one, is possession of a firearm by a person subject to a domestic violence protective order. Leah mentioned that. That's the Rahimi case. 922 G9s. This is possession of a firearm by a person who has been convicted of a misdemeanor crime of domestic violence. So again, they're not a convicted felon, but they may have a misdemeanor conviction regarding domestic violence. So let's take those individually. 922 G1. So I think a little bit of background here. We cast our net pretty wide for our program. When we look at cases and we go through those screening processes at the police departments with the agents or with the DA's offices, we're looking for a number of things. Our net is wide. We're looking for, does the instant offense, the one that we're looking at, does it involve domestic violence? If it does, that gets extra scrutiny. If the instant offense, the person has a firearm, but the instant offense is not domestic violence related, but that perpetrator has a history of domestic violence, that gets extra scrutiny. And then, of course, we have the other particularized statutes, the G8s, the G9s. We're looking for those two that are statute specific. But this G1 is a widely used statute for our initiative. This is your classic felon in possession of a firearm. And again, this could be the instant offense related to domestic violence, or somebody who has a firearm, is a convicted felon, and has a history of domestic violence. So number one, you have to prove that the defendant knowingly possessed a firearm. Number two, that before he possessed the firearm, he had been convicted in a court of a crime punishable by imprisonment for a term in excess of 1 year. In other words, a felony offense. Three is what I call your Rahimi element. The defendant has to know that he has been convicted in a court of a crime punishable by imprisonment for a term in excess of 1 year. And then last, the number four gives the federal government the right to kind of intervene. Congress has said that we can regulate firearms if they affect interstate commerce. So we have to be able to prove that the firearm possessed traveled in interstate or foreign commerce. That means before the defendant possessed the firearm, it had traveled at some time from one state to another, or between any part of the United States and any other country. So that gives us what I call the federal hook, right, to be involved in the case. Going through to the next statute, these are the G8s. This is what Gloria and Leah mentioned, the Rahimi case. Possession of a firearm by a person subject to a domestic violence protective order. Number one, I'm going to hit the highlights here. Leah said these are tricky, and that is true. We have in our office, we have set up our AUSAs who, including myself, who review these matters, but they are so complex, not only the G8s, but the G9s, a misdemeanor crime of domestic violence. We have within our office a framework where once we decide at the line level that this is a readily provable offense and that it meets the criteria of our initiative, we then consult with our appellate lawyers to go through the judgments or the protective orders, the things that bring it to our attention, to make sure that those withstand scrutiny when we get to court. And so there's a certain things that have to happen here for the federal government to be able to bring this charge. Number one, the protective order must have been issued following a hearing in which a person had actual notice and an opportunity to participate. So when you see these preliminary orders, for protection where they're ex parte, that does not meet our criteria. It does not fit the statute. They must have the perpetrator, the individual must have had actual notice and an opportunity to participate. Secondly, the protective order must contain certain language. For example, it must restrain a person from harassing, stalking, or threatening an intimate partner of such person, or a child of such intimate partner or person, or engaging in any other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child. So Dallas County is pretty good. We ran into just a few issues at the beginning of our initiative about some of the language that the protective orders that were being issued, but we worked with our DA's office to correct those, and I think they're going pretty well now. But when you get out into some of these rural counties and things like that, advocates who are listening and participating today, work with your local AUSAs and your law enforcement. Let's get the language right in these protective orders so we can use this statute. And finally, the protective order must also include a specific finding that the subject represents a credible threat to the physical safety of the intimate partner or child, or an explicit prohibition against the use or threatened use of physical force that would reasonably be expected to cause bodily injury. So as long as we can prove all of those things, we have a readily provable offense. The U.S. Attorney's Office will bring that charge. So the term intimate partner was mentioned in that statute. So I pulled the definition. Who is an intimate partner? An intimate partner means, with respect to a person, it includes the spouse of the person. It includes a former spouse of the person. It includes an individual who is a parent of a child of the person, and an individual who cohabitates or has cohabited with the person. So that's kind of a pretty broad net. With regard to the G9s, these are not your felons. These are your folks who have been convicted of a misdemeanor crime of domestic violence. First of all, what is a misdemeanor crime of domestic violence? It's a misdemeanor under federal, state, tribal, or local law. Number two, it has an element, the use or attempted use of physical force or the threatened use of a deadly weapon. And it must be committed by at least one of these relationships, these people, either a current or former spouse, parent, or guardian of the victim, a person with whom the victim shares a child in common, a person who is cohabitating with or had cohabitated with the victim as a spouse, parent, or guardian, has to be committed by a person similarly situated to a spouse, parent, or guardian of the victim, or finally, a person who has a current or recent former dating relationship with the victim. That last category of folks was added in June of 2022, prior to the Bipartisan Safer Communities Act, which was the federal legislation that changed this. We had what we call the boyfriend loophole. The dating relationship did not qualify as a qualifying relationship under this statute. But Congress fixed that, and we're very pleased because there's a lot of domestic violence going on in dating type relationships that we can now review. What is a dating relationship? It means a relationship between individuals who have or recently had a continuing serious relationship of a romantic or intimate nature. Not very helpful. They did give us some factors that you can see there. You look at the length of the relationship, the nature of the relationship, and the frequency and the type of interaction between the individuals involved in the relationship. So you can look at those three factors and anything else, quite frankly, that might shed light on whether there is a continuing serious relationship of a romantic or intimate nature. The statute does, you see in the note at the bottom, it does specifically prohibit a casual acquaintanceship or ordinary fraternization in a business or social context. That will not suffice under the statute. So I wanted to go through at this time some of I think it's one thing to go over these statutes. I think it's another to kind of shed some light on some actual cases. With regard to the 922 G1 felon in possession of a firearm, early on, our office prosecuted the United States versus James Otis Foley. Mr. Foley had been convicted previously of aggravated assault with a deadly weapon, which was a felony under state law, in March of 2011. He had beat his girlfriend and then followed her. He was brandishing a firearm as she fled in her car. In 2016, so 5 years later, he was again convicted of assaulting his girlfriend. But due to his felony conviction, he was not permitted to possess a firearm. So following his release from prison, officers responded to a domestic violence dispute, and this involved a separate girlfriend at this point in time. And they discovered Mr. Foley with a .45 caliber pistol. So he was a felon. He was in possession of a firearm. We screened that case. We accepted federal prosecution. We prosecuted it. He was sentenced to 10 years in federal prison. With regard to the G8s, the protective orders, we prosecuted a case, United States versus John Gabriel Mejia. In September 2018, Mr. Mejia was served with a protective order. This is after he had held his girlfriend and her 7-year-old daughter in his garage against their will. With a protective order in effect, he later used a 9mm pistol to threaten his girlfriend. The authorities responded, filed a case at the state level. Again, we went through that screening process. We took that case, we prosecuted it. Mr. Mejia was sentenced to 2.5 years in federal prison. Again, another example of that is the Rahimi case, as Leah mentioned. And finally, an example of the misdemeanor crime of domestic violence, the 922 G9s, United States versus Jaleel Lott. Background on that, in 2014 and 2018, Mr. Lott pled guilty to separate misdemeanor assaults, including striking his girlfriend in the mouth, pushing his girlfriend to the ground, and punching his girlfriend in the face. Following his last conviction in state court, he signed a statement claiming that he did not and would not possess any firearms. But in 2022, authorities arrested him with a firearm. He had qualifying convictions at the time. We accepted that case for federal prosecution, prosecuted it He was sentenced to 6 years in federal prison. So those are examples of the cases that we've done for each one of those statutes. Getting outside of the firearm context for just a little bit, Leah mentioned very briefly earlier stalking. This is a tricky statute that takes a lot of review of the facts, the statute. We have an appellate process again for this, whether we want to bring this charge. Federal law prohibits domestic violence abusers from stalking their victims with intent to harass, intimidate, injure, or kill the victim. This includes the mail, any electronic communication service, any electronic communication system of interstate commerce, and any other facility of interstate commerce, or foreign commerce for that matter. But these are the elements. Just real briefly, as I mentioned, you have to use one of those three, or one of those things: the mail, some type of electronic communication service, or the sort, any facility of interstate or foreign commerce. Secondly, the defendant has to do so with a certain intent, and that is, again, to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person. And that through the use of one of those three ways, the defendant had engaged in a course of conduct. So it can't just be one, it has to be a course of conduct that did one of the following. Place that other person in reasonable fear of death or serious bodily injury to that person, a member of that person's immediate family, a spouse or intimate partner of that person. And in the rest of these, we don't typically see the pet, service animal, emotional support, or horse of that person. I think I mentioned this last time. I'm not sure how horse got in the statute, but there it is. Or you can do a course of conduct that caused or attempted to cause or would reasonably would be reasonably expected to cause substantial emotional distress to that person, a member of that person's immediate family or spouse, intimate partner of that person. And I think one of the prosecutions that we did, and I credit Leah with a lot of this. She was the U.S. attorney who reviewed at a very micro level, as she should, this stalking statute. We had a case, those locally may remember this, United States versus Andrew Beard and Holly Elkins. This made the news here locally. A brief background, and I'm going to keep it very brief because this case is on appeal. But what I'm about to tell you is in the public record. Andrew Beard and the victim, which was his ex-girlfriend at the time, they had a child together. They were in a bitter custody battle. In October of 2020, Beard ambushed his ex-girlfriend as she arrived at work. He shot her in the face with a shotgun as he sat behind the wheel of her car, and he left her for dead. She staggered out of her car, surprisingly, and Beard noticed that before he left, and he went and he stabbed her to death. He was arrested on a state murder charge, but he made a $1 million bond at the state, and he was released. We got news of that, started looking at it. Again, these statutes that I've talked about take a lot of review and consultation with our appellate section. But one of the things they found a kind of a homemade silencer in this garage. So we jumped into action, and we filed a federal charge of possessing an unregistered silencer or suppressor against Mr. Beard. In March of 2021, we added cyber stalking that resulted in murder and using and discharging a firearm during a crime of violence to Mr. Beard's charges. And we subsequently added Holly Elkins, who was Beard's then girlfriend at the time of the stalking, as an accessory or party to that offense. In May of 2023, Beard was sentenced to a total of 525 months. He pled guilty. Um, he received 405 months on the stalking resulting in murder and 120 months for discharging a firearm during that offense. And the court ordered those sentences to run consecutive to one another. So it totals 525 months. And Holly Elkins, his then girlfriend, decided to go to trial. And that actually happened earlier this year. Again, she was charged as a party to that offense, aiding, abetting, assisting Mr. Beard in the commission of that offense. She was convicted by a jury. Cannot speak highly enough about our prosecution team and Leah's support on that trial. Again, the jury convicted her. It was a week and a half trial. The verdict was about 90 minutes. And the court later sentenced Miss Elkins to 2 life sentences. And again, that's a case that went all the way up to the U.S. Attorney for review and authorization to charge. And it's an example of how we can use our federal tools in bringing justice domestic violence abusers. So where are we going from here? This next slide is at AUSA Marissa Albaugh, who is online participant. She's not a participant today, but she's watching everything. She is a phenomenal prosecutor. She's a former Dallas County District Attorney, Assistant District Attorney, and she came over to us about a year and a half. It's hard to remember at this point, but Leah has dedicated a full-time domestic violence coordinator for our district, and that is going to be Marissa Albaugh. So my hope and Leah's hope is that Marissa will be kind of the outward face of this program going forward. That's her contact information for anybody who wants to jot it down. And we're going to be building this program out even more. And I thank Leah for that and her foresight and bringing us a coordinator to help us get it to even the next level. And finally, I like to leave everybody with a quote from our U.S. Attorney, Leah Simonton. It says, "For several years, our office's domestic violence initiative has led the way in prosecuting domestic abusers and putting them behind bars so they can no longer hurt others. We not only remain committed to this crucial effort, but are continually looking for ways to improve and expand our work in this area, both in terms of incapacitating domestic abusers and supporting organizations that help survivors escape abuse and provide the resources they and their families need to establish safe, healthy, happy lives." We are committed to this program. We are committed. Again, we realize that our state and local partners are on the front lines, but we are committed to supplementing their efforts in this regard. And however we help by the use of our federal statutes, we will do. Our hope at the end of this is that domestic violence abusers maybe think twice about using a firearm, and that this initiative deters the abusers and others from laying hands on their partners in the first place. But I want to thank the Texas Council on Family Violence. This is one of my favorite parts of the job. I love doing this community outreach, and I love this area. So I'm passionate about it. I hope that shows. And again, thank you for everybody for attending. And I'm going to turn it over to our next speaker.
Hey, thank you, Keith.
I'm trying to figure out how to unshare here. There we go.
Perfect. I appreciate it. I want to say thank you, in addition to Keith, to everyone who's joining today. It's obviously cold outside. The winter weather is here. But you guys and girls do an incredible job of supporting our victims, supporting people who need services, and joining in the U.S. Attorney's Office in this incredibly important mission. So thank you all. Thank you for giving up some of your time to be here. My name is Jonathan Bradshaw. As Leah said, one of my hats that I wear in the office is I'm a Second Amendment specialist, and I'm an appellate lawyer, and I have come to consult with Keith and Ted and many AUSAs in our district and then across the country, including Main Justice and DC, on federal firearms prosecutions and the Second Amendment challenges that we're getting to those federal firearms prosecutions. So what I'd like to provide you with all today is just an update on the state of the law. I can answer the question quickly: did Rahimi resolve it all? The short answer is no. There's plenty of litigation that's happening. It's actually a very exciting area of law to practice right now because it's always changing. But I'm going to put my PowerPoint up here, and then I'll kind of walk you guys through what's happening. All right, so the topics we're going to cover today, how we got here. Leah mentioned briefly the Bruen case, the Rahimi case. We're going to talk a little bit about that and how that shaped the current landscape. We're going to talk about 18 U.S.C. 922 G1 and specifically Second Amendment challenges to that federal firearm ban for people who have prior felony convictions that Keith was talking about. And then we're going to talk about some other provisions of 922. Keith hit on G8 and G9, which by definition tells you that there's other things between 1, 8, and 9. There's a G3, G5 that we prosecute. And all of the sections in 922 are being actively challenged under Second Amendment grounds. And there's lots and lots of litigation. And so we're going to talk just a little bit about some of those other statutes. We'll spend most of our time with G1. So how we got here. Here's the text of the Second Amendment. You guys have probably heard it. Growing up, I remember hearing it in high school, although I didn't spend much time thinking about it. A well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. For a long, long period of this country's history, that provision was interpreted by courts and by legal scholars to apply to a militia right. And it was not thought by many people, although some, not by many, to codify a personal right in the people to keep and bear arms. In the Fifth Circuit, that changed in the early 2000s. The question came before the Fifth Circuit, and they held that that second clause is an operative clause and it protects the right of the people. And the Supreme Court eventually joined on with that reasoning in a case called Heller, excuse me. And in Heller, the Supreme Court said the Second Amendment protects a individual right to keep and bear arms. And after Heller, there was much question about, okay, if we have an individual right, what does that right protect? And many defense lawyers argued that that individual right should bar prosecution for any firearms-related offenses, federal or state, and certainly simple possession of a firearm offense, right? Just because I have a felony doesn't mean that the Second Amendment allows the federal government or a state government to bar me from having a firearm. And after Heller, every single circuit court rejected that view. They said the Second Amendment does not apply in that way to bar governments from keeping felons from firearms. And all the circuits were unanimous on that point. And so we saw a flash in the pan of litigation on it, but then it really got quiet and there wasn't a lot of litigation until the Bruen case that Leah mentioned. Bruen had nothing to do with a federal firearms prosecution at all. Bruen was about a New York licensing regime and what citizens of New York had to do to carry a handgun, to get a concealed permit license to carry their handgun. But in the test that the Supreme Court announced in Bruin reset the stage in terms of what federal courts look for when they do a Second Amendment analysis. And for the first time, the nation's history and tradition of firearms regulation became the key to analyzing whether a current firearms restriction was constitutional. So comes the Rahimi case. In Rahimi, the Fifth Circuit says, look, this nation does not have a well-established history and tradition that would support a G8 prosecution, and therefore G8 is facially unconstitutional. And as Leah mentioned, the Department of Justice, we appealed that decision to the Supreme Court, and thankfully the Supreme Court granted certiorari, and they said, no, the Fifth Circuit was analyzing the question too narrowly. The Fifth Circuit was looking for a sort of one-to-one categorical match in the history of the country. They wanted a law just like G8, and instead we need to look for what are the principles underpinning our legal tradition. And one of the principles that the Supreme Court identified in Rahimi is that courts and magistrates have long had the power to disarm those who have a propensity to misuse firearms. And so drawing on that history and tradition, the Supreme Court said that G8 fit comfortably in that history and tradition. But what Rahimi did not do was answer the question that was on a lot of people's minds during the Rahimi argument, including Justice Barrett, which is what do we say about the federal felon in possession ban, 922G1? Is that always constitutional? Is it constitutional sometimes? And so what the Supreme Court has done is push that question back down to the circuit courts. And that's where we're seeing a lot of litigation. So that segues to Second Amendment challenges to 922G1. As Keith said, that's our felon in possession ban. Keith went through the elements of that statute with you. But I will tell you, that is a frequently charged and so frequently challenged statute. In my time in the office, I would say that 922G1 prosecutions are probably, if not definitely, the single most charged offense. And that's not just the Northern District of Texas, that's countrywide. Federal prosecutors use this charge a lot. For reasons that are obvious. If you have someone who has a prior felony conviction, and then that person has a firearm, they present a unique danger to the people around them, and especially in the context that we're talking about today, in the domestic partner context. And so federal prosecutors have long been ready and able to charge 922G1s where someone has a prior felony. But those cases now are facing Second Amendment challenges at every turn. So I put together these slides a few weeks ago. I got on a legal research database. I looked for cases that came out after the Supreme Court's Rahimi decision that touched in only federal court, not even state court. I just said Second Amendment and 922G1, and it produced over 500 results. I would guess that number is deeply underrepresented. First of all, if I updated it and ran the search today, it would probably be over 750. And that does not include lots of orders from district courts around the country who are on the front lines and assessing these challenges. That's just reported decisions. So that these cases are everywhere. The department's position, of course, is that 922G1 is constitutional in all of its applications. Regardless of what your prior felony conviction is, the department's position is that under 922G1, under the plain language of that text, you are barred from possessing a firearm. However, the circuit courts now, after the Supreme Court's Rahimi decision, are deeply divided over the constitutionality of that statute. So far, every circuit has said that G1 must be constitutional in some applications. It certainly can be constitutionally applied to people with prior convictions for murder, And believe it or not, we do have people who have a murder conviction, do long times in state penitentiary, get out and then possess a firearm and are prosecuted federally. But the circuits are deeply divided over what we call as applied challenges. So a particular defendant says, under my circumstances, the government cannot lawfully disarm me. That violates my Second Amendment rights. So a quick map of these are the federal circuit courts. If you're like us and you're in Texas listening today, you are in the Fifth Circuit, along with Louisiana and Mississippi. There are several other circuits. All over the country is divided into different circuits, but this just gives you a sense of where the circuit courts are geographically. Let's talk briefly about the Fifth Circuit's approach to G1 cases so far. So the Fifth Circuit, just in the last couple of months, has issued two binding precedential opinions. One is called United States versus Diaz, and the second one is called Bullock. And this sort of Diaz-Bullock framework sets out the standard in the Fifth Circuit. So Diaz is an interesting case. In Diaz, the defendant had numerous prior felony convictions, but one conviction he had was for theft, and specifically theft of a car. And what the Fifth Circuit did is they said, theft of a car is analogous to the founding era theft of a horse. And because at the founding, theft of a horse was punishable by death or estate forfeiture, then that shows that the relatively smaller punishment of disarmament is consistent with what the founding generation would have thought that a government can do vis-a-vis thieves, right? So if you have a theft conviction at the founding because the government could execute you, then necessarily people at the founding thought that you could lose your right to a firearm. And so for that reason, the Fifth Circuit held that prior theft convictions can be the basis for disarmament, but the court was explicit that it was not deciding anything beyond that case, and it was inviting defendants who have different types of convictions to challenge their G1 prosecutions. The next published case was Bullock. And in Bullock, Mr. Bullock had a prior conviction for manslaughter and also aggravated assault with a deadly weapon. And what the Fifth Circuit said in addressing his Second Amendment challenge was, of course, throughout history, the governments have long been able to disarm the dangerous. And Mr. Bullock is clearly dangerous. And so therefore, the government can disarm Mr. Bullock. Now, what we've had in the wake of this Bullock and Diaz framework is numerous challenges to federal firearm prosecutions. So Keith Robinson and I just yesterday were in a nearly hour-long hearing in the district court for a defendant who has 10 prior felony convictions. He has a burglary of a habitation, 7 burglaries of buildings. He has an evading arrest, and he has a RICO-type offense for running a burglary ring. And we had a spirited debate with the defense lawyers about whether the Second Amendment would bar his prosecution or not. He was later found in possession of a stolen firearm, and so we charged him with 922 G1. We're awaiting the district court's decision on that case, but that just sort of shows you this is the landscape we're in. So where these 922 G1 charges used to be about, or only about, can the government prove the elements of the offense that Keith went over? Now we are seeing a second layer of litigation, which is, does the Second Amendment bar this prosecution? And for all of you in the field, in the Fifth Circuit, your prosecutors may be coming to you asking questions beyond simply, does this guy have a prior felony, or this gal have a prior felony? Now they're asking, look, we need records from this person's entire life. We need to know what their misdemeanor convictions were, what their arrests were. Have they ever had any kind of assaultive conduct? Because one thing the government attempts to show in many of these cases that this person is dangerous, even if their felony conviction is for non-dangerous conduct, for example, counterfeiting or forgery. What we have is, and I'm sure you all see this a lot, you have a defendant with a sort of non-violent felony, but maybe he has numerous assaultive misdemeanors, right? And so one thing the government is going to do is argue that that person is dangerous and therefore can be disarmed under the Bullock framework. So that's where the Fifth Circuit is. Let's look at where a few other circuits are. A slim majority at this point of the circuits say that it's constitutional, that 922G1 is constitutional in all of its applications, although their reasoning is a little bit all over the map. In those circuits, any prior felony conviction means that the government can disarm you consistent with the Second Amendment, and your Second Amendment challenge to that prosecution would necessarily fail. So this is a quote from the Eighth Circuit recently in the Jackson case, and it just says, "There's no need for felony by felony litigation." So if I had a crystal ball and I had been smart enough to be an AUSA in the Eighth Circuit, then maybe I would have worked myself out of a job because I wouldn't get to help Keith with all of these interesting as-applied challenges. But in the Fifth Circuit, this is certainly not the law. Let's talk about the Sixth Circuit. If you go back to that map I put up earlier, the Sixth Circuit is centered in Ohio, and the Sixth Circuit has come up with what they call just simply the dangerousness test, and it doesn't so much matter what the defendant's prior felony conviction was for. It matters whether he or she is a danger. And the burden is on the defendant to come forward and say, hey, I'm not a danger for the following reasons. But if that person can establish that, for example, maybe they had been convicted of a simple theft and had no other dangerous conduct, that person might be able to be prosecuted in the Fifth Circuit, but potentially not prosecuted in the Sixth Circuit. And that leads us to the Third Circuit's approach in a recent case called Range versus Attorney General. And in Range, the Third Circuit said, 922G1 would be unconstitutional to a man named Brian Range, who has many, many years ago been convicted of lying about his income level in order to get food stamps. We're going to tell you it's unconstitutional as applied to Mr. Range, but we're not going to tell you who it would be constitutional as applied to and who it would not, right? So the Third Circuit has sort of left their district courts on the front lines doing all of this work, trying to figure out what the Supreme Court means, what the Third Circuit means, where the different circuits are, and trying to litigate this. I guess you can take away from my presentation the obvious, right? Right now, the law is inconsistent, and the circuits are deeply divided, and they're a little bit all over the place, and that calls out for the Supreme Court to get involved. I think most scholars who study this area will anticipate that the Supreme Court will likely take a 922G1 case sometime in the coming years, maybe not this term, but if not this term, probably next term, to give these lower courts and prosecutors and defendants some guidance. It is a untenable position to say to the courts, look, this person may be a felon in our jurisdiction, but and therefore disarmable, but he's not in another circuit, but maybe he is in this circuit. And so everyone sort of needs clarity on the G1 question. Okay, quickly, other provisions of 922. So as Keith went over a couple of them, here's a list of just these are sort of John shorthand on what each provision of 922G prohibits that type of person from having a firearm. I want to note the G3, the unlawful user or addicted to any controlled substance. In the Fifth Circuit, that used to be a charge where we would look sort of second, it would be a second look. If they didn't have a felony, we might look, are they a chronic user of a controlled substance? Do they use methamphetamine constantly, heroin constantly? Can we say that they're disarmable for that reason? Congress has given us that tool, but recently the Fifth Circuit has struck down several 922G3 prosecutions. And so what the Fifth Circuit has said is that a person must be presently intoxicated or at least have used quite recently, although the court hasn't yet defined the tours of what quite recently means, in order to be prosecutable under under 922G3. Otherwise, if the government can't prove the last time that they used a controlled substance, then that prosecution may be barred by the Second Amendment. So again, for all you folks in the field, you may have your prosecutors asking you like, look, I really would like to bring a 922G3 charge. What we need to figure out is let's do some social media search warrant returns. Let's do some witness interviews and try to figure out when was the last time this person had used. Can we do a drug test? Do we have any results that suggest, after they misused their firearm or they were arrested, that they tested positive shortly thereafter for some use of a controlled substance? And all of those facts may help inform whether we can bring a 922G3 prosecution, at least in the Fifth Circuit. That's all I have for you today, guys. I just want to thank you again for your time. I'll also be sticking around for questions. So if you have any burning Second Amendment questions, I'll be happy to answer them. And otherwise, I'll pass it over to Ted. Thank you.
Thanks, John. And I want to thank Leah and the Texas Council on Family Violence for inviting me to speak today. And this is a pretty cool experience for me. I won't say it's the only reason I'm an assistant United States attorney, but one of the reasons I am is the work that I did in law school with the domestic violence clinic at UT Law, working with Gina Lungwitz there. That experience gave me a lot of firsthand interaction with victims of domestic violence. And so this is an area that's really near and dear to my heart. And as Leah mentioned, I'm an AUSA in our national security and cyber crimes section. So I don't get to deal with domestic violence, I would say, on a day-to-day basis. But I do want to talk to you all a little bit about a case that I recently handled involving federal supervised release violations and domestic violence. And so just to give you a little preview of what I want to talk about, federal supervised release is different than a brand new criminal prosecution. It's different than state parole. So I want to talk a little bit about what that involves and how new law violations can constitute a violation of a previously convicted federal defendant's supervised release. And then I want to speak a little bit about the case that I worked on, United States versus Jose Negron Cardona, which was a federal supervised release violation involving several incidents of domestic violence. So federal supervised release is a form of post-incarceration supervision for convicted felons that's provided for by statute. Specifically, that's 18 United States Code section 3583. And the purpose of supervised release under the Sentencing Reform Act of 1984 is to facilitate federal defendants' reintegration into society, to ensure compliance with the law, and to reduce recidivism. And the requirements of supervised release involve sort of an array of conditions, both mandatory, which means they're required by either federal law or the United States Sentencing Commission guidelines, and then discretionary conditions, which are determined by the judge based on the defendant's the individual needs. And those are, and an important aspect of this is that they are determined at sentencing, so not after the defendant has been released from federal incarceration. Supervised release is different than parole. And I've put together this chart, which has a few of the characteristics that make them different. I think most importantly is that supervised release is different from parole in that it is not early release from a prison sentence. It is a period of supervision that commences after the defendant has served the bulk of, if not the entirety of, their federal prison sentence. It is imposed by a federal judge at the time of sentencing. It is not decided by a parole board as conditions of early release. Almost all federal offenders are required to serve some period of supervised release after their sentences. I won't say every single one, but the vast majority of. And the release period is, again, in addition to that defendant's original sentence. It doesn't reduce their time in prison. And it is supervised directly by the U.S. District Court through the United States Probation Office. So it's not subject to a state parole board, which is independent from the courts. Conditions of supervised release. If the court determines that a period of supervised release is appropriate and imposes it at sentence, it will also at the sentencing determine a combination of both mandatory and discretionary conditions of supervision. And these conditions the mandatory conditions are set forth in statutes and the sentencing guidelines. The discretionary conditions are typically based on the type of offense, the defendant's criminal and personal history, and other factors that the judge considers at the time of sentencing. So mandatory conditions apply to all categories of offenders, and they are set out in, as I said before, federal law and the U.S. sentencing guidelines. And these include, among other things, that a defendant not commit another crime while on supervision, that they not possess or use controlled substances, that they make restitution to victims, pay fines, assessments imposed, and in a lot of cases, if not all, submit to drug testing. Discretionary conditions are a little different, and the federal judges have authority to impose discretionary conditions of release based on the defendant's personal history, the offense of conviction, and other factors. And these can include things like attending substance abuse classes if the defendant is convicted of a drug trafficking crime and there's evidence that comes out in sentencing that they have an addiction problem themselves. It can also include mental health treatment. In federal crimes of domestic violence, it could include attending domestic violence counseling classes. And in sort of federal sex offenses, we see a lot of discretionary conditions that involve limiting access to a computer or monitoring of internet access. The service of supervised release is supervised by a U.S. probation officer. That is an office of the United States courts. So that officer reports directly to the district judge who is in charge of supervising the defendant. And that term begins immediately following the defendant's release from prison. And it typically occurs in the U.S. judicial district where the defendant was sentenced, although it may be transferred to another district based on the defendant can petition to move somewhere else, more convenient for him. Violations of supervised release. So if the defendant violates one of those mandatory or discretionary conditions of supervised release, the district court can do several different things. They can modify the conditions, either add or remove conditions, depending on the defendant's success at complying with those. It can terminate supervised release before the expiration date that was originally set at sentencing, or it can revoke supervised release and impose a term of imprisonment in addition to what the defendant has already served. And I want to focus specifically on revocation proceedings. And when courts receive notice from the U.S. Probation Office that a defendant has violated a condition of supervised release, they engage in a three-step process. That includes determining whether the defendant has violated one of those conditions. They must then make a finding on the record that a revocation of supervised release is the appropriate remedy for that violation. And then third, they can impose a penalty. And that penalty, like I said, can be additional prison time. It could also be sending someone to rehab or adding or subtracting conditions of release that are previously set. The revocations are determined at a hearing on the record. And so the court will hold a hearing in which they'll determine whether to revoke and what that penalty will be. And those hearings are governed by a lower standard of evidence and a lower standard of proof than a criminal trial. So the court only needs to find that the defendant violated a condition of supervised release by a preponderance of the evidence, not beyond a reasonable doubt. Turning specifically to new law violations, it is mandatory condition number one set forth in the U.S. sentencing guidelines that the defendant shall not commit another federal, state, or local offense. The guidelines also set forth grades of violations. So there's grades A, B, and C, as you can see on this chart. And a grade A violation would be the most serious, and that constitutes a new offense punishable by more than 1 year of imprisonment that falls in certain categories of particularly serious crimes, or a new offense that is punishable by more than 20 years of imprisonment. A grade B violation, still very serious, constitutes any new offense punishable by more than 1 year of imprisonment. So essentially any felony. And then a grade C, which is the least serious, constitutes a new offense that's punishable by less than 1 year of imprisonment. So in federal terms, that would be considered a misdemeanor in most cases, or a violation of any other condition of supervised release. And what that would be is someone who's been ordered to take mandatory drug tests at regular intervals, who has not shown up for those appointments. And we sometimes refer to those as technical violations rather than new law offenses. Notably, when a court makes a determination on a revocation of supervised release in the case of a new offense, it's not necessary for the court to find the conviction is not necessary for the court to find a violation of supervised release. So the U.S. attorneys who argue these cases need to prove by a preponderance of the evidence that culpable conduct has occurred and the defendant is responsible for that. And there are also lower standards at these hearings for admission of evidence. So hearsay is often admissible, although not always, as I'll speak about in a little bit. Turning now to the case that I worked on, the United States versus Jose Negron Cardona.
This is Leah, just asking, are there slides that, I'm just checking, slides that you're sharing?
Yes, I'm sorry, are they not up?
No.
Oh, okay. Well, let me put those up.
Just throw those up. Thank you.
Can everybody see those?
Yes, we can see them.
Perfect. So Mr. Negron Cardona, originally from the territory of Puerto Rico, and he was convicted in 2009 of conspiracy to possess with intent to distribute cocaine base and possession of a firearm in relation to drug trafficking. And in 2009, he was sentenced to 211 months in prison for both of those crimes, which was later reduced to 157 months and then 120 months of supervised release. In May of 2020, Mr. Negron Cardona was released from federal incarceration and began his 10-year term of supervised release. And he, sometime after that, moved to the Northern District of Texas to live with his girlfriend, who I've abbreviated as female victim here. And shortly after moving to the Northern District of Texas, began engaging in a pattern of domestic violence incidents with his long-term girlfriend. So in February of 2023, the female victim reported an assault involving strangulation to the Grand Prairie Police Department. Grand Prairie attempted to follow up with the female victim, but received no response. And during the course of the follow-up, there was another, Mr. Cardona was ultimately arrested by the Grand Prairie Police Department for aggravated assault with a deadly weapon. Unfortunately, the female victim recanted her initial statements, which was that Mr. Cardona had threatened her with a knife and a hammer during an interview with the Grand Prairie Police Department. However, the U.S. Probation Office in that case did file a petition with the district court alleging a violation of Mr. Cardona's terms of supervised release, specifically that mandatory condition that he not commit a new law offense. So the courts had a preliminary hearing in which the probation office and the U.S. Attorney's Office had to provide probable cause that Mr. Cardona had committed a new offense. And Mr. Cardona brought the female victim in, and she took the stand and recanted on the record and said that the assault had not happened. And so the magistrate judge who was hearing that proceeding found no probable cause, and the petition to revoke Mr. Negron-Cardona's supervised release did not go forward. As happens quite frequently in these cases, about a year later, the Grand Prairie Police Department was called to the female victim's home, and the female victim provided a detailed statement about another episode of domestic violence. And specifically, what had happened is she had heard Mr. Negron-Cardona on the phone with another woman saying negative things about the female victim. When she confronted him about it, he attacked her, and I want to show some photos of the scene. He smashed a statue over her in the garage of their home, causing cuts to her head and face. You can see a bloody handprint here on the wall of the garage. The altercation continued into the female victim's home, where she attempted to defend herself with various sculptures and things that she had around the house, leading to more things getting broken. During the course of the interaction, Mr. Negron-Cardona grabbed one of his steel-toed work boots and used it in his hand as a club to smash her around the head and face until she lost consciousness. And at that time, after she regained consciousness, she escaped the home and used a second phone that she kept in her car to call 911. The Grand Prairie Police Department interviewed her. She this time did not recant the statement. She maintained her account of what had happened on that night in June. And on June 10th, probation again filed a petition to revoke supervised release against Mr. Negron-Cardona, alleging a Class A violation of his supervised release. So that is the most serious. 1 month later, the magistrate judge found probable cause after hearing that Mr. Negron-Cardona had assaulted the female victim. And after that probable cause had been determined, Mr. Negron-Cardona waived his detention hearing, which he was also entitled to. And so he was incarcerated during the rest of the proceedings here. Mr. Cardona did contest substantively the petition that he had revoked his supervised release. And oftentimes, the U.S. Attorney's Office will see this in cases of new law violations. The defendants are hesitant to admit to revoking their supervised release, even when the evidence of a new law violation is overwhelming, because that admission in supervised release proceedings can then be used as an admission of guilt in a substantive state trial for aggravated assault or whatever the new law violation happens to be. My colleague, Michelle Winters, who I also have to thank because she did a lot of the prep work on this case, and I prepared for a hearing which was set for November 6th in the U.S. District Court for the Northern District of Texas in front of Judge Ed Kincaid. And one of the things we were wary of as prosecutors was putting the female victim back on the stand after she had recanted her testimony in the previous violation proceedings. But we briefed that issue. We prepared for the hearing to put on evidence of the assault through the responding Grand Prairie police officers and the detective who investigated the assault. But at the hearing, the court ruled that the female victim must testify and that the hearsay evidence of her assault, which would have been the testimony of the police officers, could not come into that proceeding. And so we had to put the female victim on the stand with knowledge that she had recanted in the past. And I will say what was very helpful there was having had the experience at the UT Law Domestic Violence Clinic, because I had spoken and worked with victims before, and it was helpful in eliciting testimony about what had happened that night, which can be very painful and difficult for victims to explain. She was a rock star on the stand. Her testimony matched exactly the statements that she had given to police officers and detectives, that he had smashed her around the head with statues, that he had hit her with a steel-toed boot, and that it had caused fairly serious injuries to her head and face. Perhaps the most impactful part of the testimony, in my opinion, was fronting the issue with her previous false statements that assaults hadn't happened. And the way we did that was ask her, you have recanted before, is that right? And she said yes. And I asked her, is that because you're afraid of him? And she said it is. And I said, are you still afraid of him? And she answered affirmatively, and we stopped the testimony at that. And it ended up being a pretty powerful moment. The court ultimately found that Mr. Negron Cardona had committed the new law violation of assault, and in determining the sentence, sentenced him to the maximum penalty available, which was consecutive terms of 2 consecutive terms of 60 months for a total of 10 years in prison. And so this was a big success for our office. And the takeaway is that new prosecutions are not the only tool we have available in our toolbox. That federal defendants who are on supervised release, there are tools in our toolbox we can use to support victims, support their victims, and remove those victims from dangerous relationships. And that's what happened here. And I've included my email address here in case you have questions for me about that case, and I'm happy to discuss with anybody, and I will also be sticking around for questions. Thanks.
Tabitha, I think you're muted. There you go.
Yeah, thank you. My name is Tabitha Harrison. I'm with TCFV. I'm the Coordinated Community Response Manager. I'm just going to come on and go over a little bit of our data and kind of how that relates to what we've been talking about today. Let me get my slides up really quickly. We all see there?
Yes.
Thank you. So, like I said, my name is Tabitha Harrison, and I'm with TCFV. Today, we're going to be talking about a couple of projects that TCFV holds that allow us to look at the data surrounding domestic violence homicide and how that relates to legal and policy issues that we've discussed today and are being continuously discussed in the judicial system. There we go. So why this matters? Domestic violence and firearms is, of course, a lethal combination. We've talked about a few different stats today, how the mere presence of a firearm elevates the risk for homicide by 500%. Decisions like the Rahimi decision and efforts like the domestic violence efforts that are being taken on shape enforcement and policy. Certainly at a local level, whenever we're looking at federal involvement, federal policy, federal initiatives, that's going to have an impact on the local community level. So the goal here is to align the research insights with the legal framework to enhance public safety. What does that mean? That's just basically a complicated way of saying, make sure that everyone knows what we know. So again, I'm going to go through some of this kind of quickly. We're going to talk about the report so that we're all on the same page. We're going to talk about the role of firearms, the Rahimi decision and its implications for our research and for survivors, and then policy and enforcement recommendations that have come from our research. So I keep talking about the reports, right? So whenever I say the reports, I'm talking about the Honoring Texas Victims Report and the Domestic Violence High Risk Teams Statewide Report. The Honoring Texas Victims Report is a yearly report. It's an annual review of intimate partner homicides in Texas. We look at demographics, we look at trends, we look at the methods that were used whenever the homicide was committed. And just as importantly, we look at the surrounding circumstances, the nature of the relationship, whether or not there's evidence that the perpetrator was a prohibited possessor, things like that. The Domestic Violence High Risk Teams report is a little bit more in depth. It's the data that we get whenever there's an intervention in place with the goal of preventing a homicide. So high risk teams are, for those of you who aren't familiar, they're community-based teams. It is essentially looking at the highest risk domestic violence cases within that jurisdiction and having the local DV program, law enforcement, prosecutors, and other community partners at the table to take a team approach to resolving these issues and improving safety outcomes for survivors. Working with those teams, we get the opportunity to gather quite a bit of data on the cases that are coming through their doors. Some outcome data, but mostly looking retroactively at the circumstances surrounding this high risk assault that brought the client to their services. It gives us an opportunity to highlight patterns of these high risk cases before and hopefully without a homicide occurring. It gives us a lot of information on intervention points. So what do we know from our reports? Honoring Texas victims, of course, that's, a listing of people that we've unfortunately lost. Looking at those cases, 72% of female DV homicide victims were killed by firearms. Another interesting factor there is the homicide-suicide cases that are showing up in our research and are so frequently occurring. That also extends to family annihilation cases that have an underlying current of domestic violence. What all of those have in common is this high prevalence of firearms and the availability of a firearm. The DVHRT report is showing firearms as a tool of intimidation and a way or a indicator of escalation within these high lethality cases. I'm sure a lot of you have heard the term the big three. Firearms, stalking, and strangulation are those big high risk factors. Firearms, not only just the mere presence, but the way that the offender is utilizing that firearm within the relationship. If they are utilizing it in any sort of way, apart from just making it known that it's available, firearms are frequently used as a way to intimidate victims, survivors, into not reporting, into not leaving the situation, just a tool of paralyzing fear. We also see a lot of post-separation risk that's also reflected in our Honoring Texas Victims report, that whenever a survivor has left the relationship and there's access to a firearm in play, that risk to them is significantly higher after leaving the relationship. So one of the ways that we see high risk or high lethality risk cases coming to DVHRTs is through the use of a risk assessment. I'm not going to go into a lot of detail about it. It's pretty technical, but there are several risk assessment tools that are used across Texas and across the nation to help law enforcement and programs identify those cases that are at the highest risk of becoming homicides. So these risk assessments contain a battery of questions, some of them quite similar from one risk assessment tool to the next, that help determine how high that risk is. Not only does that assist law enforcement in the programs for being able to resolve the issue appropriately and with the appropriate level of speed and concern and attention, but it also many times highlights for the survivor just how dangerous their situation is. So what are we seeing from these risk assessments? We're seeing that the high lethality risk often precedes homicides. That sounds kind of like a misnomer, right? But whenever we're looking at intervention points, being able to see instead of retroactively what was happening before the homicide, to see it in the context of prevention of a homicide is so important to shaping our work and shaping policy. Again, we're seeing intimidation through firearms as a strong prediction of future violence, and not just homicidal violence. It's an escalation tool. It's an escalation measure that a lot of abusers will use whenever they're ramping up the intensity of their abuse by having the firearm come in as an intimidation tactic. Barriers that we're seeing: inconsistent enforcement of firearm surrender laws. And we're going to get into that a little bit as far as the policy pieces of this. So whenever we talk about the Rahimi case and just how important it was in looking at these high-risk factors, especially with firearms, we have to look at the way our findings align with not only national findings, other research projects, but also with the way the court viewed disarmament of dangerous individuals. Whenever we heard the term, I think a lot of us kind of held our breath a little bit whenever the term tradition came out in the context of the Rahimi case, and it was being so widely used because we know that domestic violence is something that wasn't necessarily talked about in a historical perspective. And we wondered how tightly the court was going to cling to that tradition piece. Luckily, the court decided that it is part of our tradition to allow governments to disarm individuals who present a credible threat to the physical safety of others. In other words, that dangerous individual holding. So connecting all the research, again, the ruling in the Rahimi case validates the findings in the DVHRT and the HTV reports about firearm threats. It emphasizes the importance of judicial determinations for public safety. I had a colleague once, just in a passing conversation, she and I were talking and kind of expressing our frustrations with different things surrounding the DV movement. And she said, I just wish they knew what we know. And that was really striking to me because in this conversation, it was the legislature that we were talking about. But it really is important to make sure that as a policy piece, not only does the legislature know what we know that we're getting out of this research, but also that the court system and the judicial system knows what we know. And I think that there was a lot of opportunity within the Rahimi case to spread that awareness, and it was a beautifully executed operation. It also highlights the need for robust enforcement mechanisms. That's kind of the good and the bad weighing out. That's another thing that we see so frequently in these cases is that the offender may have been a prohibited possessor, or there may have been a prior threat with a firearm, and it just wasn't enough to stop that person from having access in any meaningful way. So closing the gaps, whenever we're talking about firearm surrender protocols, that is something that draws a lot of ire, right? But the issue is that we have all these wonderful laws and all these wonderful provisions that do allow for prosecution should a person with a domestic violence offense or with a protective order against them be found in possession of a firearm. What we don't have is a robust system with which to get those firearms away from them. So whenever we're looking at, let's say, the issuance of a protective order, the judiciary might be saying to this person, you can't have a firearm, but in most jurisdictions across Texas, there's no follow-up mechanism after that to say, okay, show us you got rid of the firearm, or here's where you take it. That's what we're talking about when we talk about firearm surrender protocol. Also, expanding lethality statement or assessments nationwide. There are many jurisdictions across the nation who are using lethality assessments to aid in their prosecution of these cases and assisting the victims. um, wider use of those risk assessments will not only give us more information on what's going on from place to place, but also allow for a more comprehensive wraparound approach from a federal level. And enhancing survivor support and law enforcement training, something that we see very frequently is a misunderstanding of the laws by both law enforcement and those who are experiencing violence. Making sure that we are equipping our law enforcement with the tools that they need to be able to confidently prosecute these cases and be able to confidently talk the victims through the information they need to know is absolutely critical. And improving data collection for informed policymaking. Again, going back to that piece of, I wish they knew what we know. Well, there's only one way to do that. We've got to get the data, we've got to get the information, and we've got to get the voices of survivors elevated to the highest levels, even if that means in a Rahimi case where it's going before the Supreme Court. It's all about protecting survivors and preventing violence. And not only are we looking at the immediate danger to the partner against whom the violence is targeted, but we're also looking at community-wide danger. There is a very high risk to law enforcement, and there's a very high risk to children and community members whenever there's a high risk of homicidal violence against a partner. As we said before, firearms significantly escalate DV lethality. The Rahimi decision enforces that targeted disarmament. This disarmament is well within the traditions that we've set. And collaboration and evidence-based policy are essential, making sure everybody knows what we know. And that is going to be it for me. I believe we're going to be moving into the Q&A next. Thank you so much, and I hope you all have a great day.
Thank you, Tabitha, and thank you to all of our presenters who presented this morning. Your knowledge, expertise, insight, and stories are so moving. And thank you to all of the attendees who have joined us this morning. So we are now at the live Q&A session. I'd like to invite you to use the Q&A button or function at the bottom of your screen. You can feel free to submit any question about any of the information you've heard today. We've actually had a few come in already, and we've answered via written responses. But for anybody who didn't catch those, I'd like to do a quick recap. Again, in the meantime, please type in any additional questions. We are at our live Q&A time right now. A few of the ones that have already come in, somebody asked, is the special program in Dallas that Keith Robinson mentioned, is that also extended to other cities like Houston? USA Simonton, you provided a written response. May I invite you to come back on screen and just give a quick verbal recap of that?
Yes. I know, our viewers today are throughout the state of Texas, and some of you may not even be in Texas. So I wanted to explain how federal districts work in terms of the scope of where our office is looking for domestic violence related abusers and what other districts are doing. So there are 4 districts in Texas under the Department of Justice. And we are in what's called the Northern District of Texas, which actually encompasses the most counties of the 4 districts, but still is only in one part of the state. So we cover 100 counties, and roughly it is Dallas is our eastern border. And then we go all the way past Fort Worth, all the way past Lubbock to the New Mexico border, and then the entire panhandle, including Amarillo. That is all in our district. So if you have an organization in our district, then we would be your district that would be helping prosecute cases related to potentially some domestic violence victims or abusers that you would come into contact with. And I know Keith talked about Marissa Albaugh, who I want to give a shout out to Marissa. I know she's watching. She is going to be leading our outreach efforts to domestic violence organizations. So that is a newly created position that I made, and I have tapped Marissa to be that person. So feel free to contact our office and talk with Marissa if you'd like to engage in any outreach efforts with our office, because she would be your contact person there. You could just contact our main number and ask to speak to Marissa, and that is 214-659-8600, 214-659-8600. As I mentioned, there are 3 other districts in Texas: the Eastern District, which covers basically everything east of Dallas, including starting in Collin County, Plano, and going to the Louisiana border, and then it goes all the way down to the outskirts of Houston and all of Beaumont. That is the Eastern District of Texas. The Southern District of Texas, the hub of that is Houston, and they also have some border area. And then the Western District of Texas is El Paso all the way to Austin and down to San Antonio and all that border area that's in the western part of the state. All of those U.S. attorneys are very focused on domestic violence issues in their communities and on prosecuting federally domestic violence abusers. And they have they either have programs or are creating programs that are like what we have in our district. And even when those U.S. attorneys go to their next adventure, their offices will keep doing that. So, for example, in the Eastern District of Texas, U.S. Attorney Damian Diggs announced during our last press conference that we did with Gloria to honor domestic violence survivors in Texas, that the Eastern District was creating something they call Operation Purple Ribbon, which obviously is, a call out to the purple ribbons that you wear for domestic violence issues. And that is their version of that. So if you were in a different part of the state, I would just call the U.S. Attorney's Office. You can just Google U.S. Attorney's Office Houston or U.S. Attorney's Office San Antonio or Austin, and it should, pull up the office, and then you call and then you ask, can I speak to, I would just say the violent crimes section chief, and that person should know who the domestic violence coordinator is for that district.
Thank you. Another question just came in, quite a long one, but the end of it, and I think the main point is that one of the DOJ memos mentioned earlier in one of the presentations addresses the knowledge that there is a restraining order, but does not address knowledge that the possession of a firearm is illegal. And then they go on to say, if the judges knew that a restrained person could be subject to federal prosecution, but they failed to notify them of that, they might be more willing to modify the protective order to include those warnings. Is that feasible?
So this is where I'm going to go ahead and take that one, because this is where I would actually love to see all the different versions of restraining or protective orders that we have, even in just the state of Texas. I'm familiar with the one that we had in Rahimi, which actually did provide warnings to Mr. Rahimi about possession of a firearm being illegal now that he was under a protective order. So, and it's, of course, because we want it to be a deterrence factor. We don't want them to have to be prosecuted. We want them to know they can't have a firearm from the minute they get that protective order. So I totally understand where you're coming from on that. And so it just kind of depends. Yes, I mean, ideally, we would have that in every type of protective or restraining order that we have in the state. And that is something we can, certainly try and amplify that through our types of offices or the Justice Department. That's also something that I think domestic violence organizations can talk about and discuss and emphasize. It can be sort of a joint responsibility of ours to push that. But yes, it is interesting that in the protective order in Rahimi, which was from the Tarrant County District Courts, followed exactly what we needed to prosecute him in the federal system. And so there are types of that out there, but I understand that there are all kind of different types. One of the things I want to do, this is a little side note, but one of the things I'd like to do in my next chapter after being U.S. Attorney is serve as a sort of liaison, because I understand the legal framework so well, and talk with domestic violence organizations and look at some of the protective and restraining orders you have to kind of figure out this would work, this wouldn't work. Maybe you should advocate on behalf of something like that, a warning in that type of protective order that they shouldn't have a gun. So that's something I'd like to dig in deeper to that I haven't had the experience with yet.
Right.
Can we offer advisory opinions? No, we don't offer advisory opinions, but we do outreach even to courts. I will say that Erin Neely Cox, for example, when she was U.S. Attorney, she would create pamphlets that the district judges in Dallas County, when they were dealing with certain types of offenders related to domestic violence issues, could hand out. And that's something that we're considering doing. We have to do it in sort of the post-Rahimi landscape, but we can advise people of what the federal law is So that's kind of a version of an advisory opinion, but it's more just sort of an outreach technique we use. We also have, I will say, some outreach materials that we would love to distribute to your domestic violence organizations that you can give to domestic violence victims in terms of how to report cyberstalking, how to report it if their domestic partner that they're afraid of has a gun, and maybe they are a prohibited person because they have a prior assault conviction, they're under protective order, they're a felon. So please reach out to Marissa about that too, and she will loop in our public affairs officer who helps create those materials.
Excellent. And with that, I think our Q&A is at an end. I'd like to invite the closing.
Well, I want to give a shout out again to Gloria, who is just fantastic. She is such a great partner. And one of the ways in which she's a good partner is not only in everything that she does with us, but because she is so connected to all of you. And when she's thinking of initiatives, she's thinking of it not just obviously in terms of TCFV, but also in terms of all of your organizations and what can benefit your entire community. So I want to thank her for connecting us with you. And I want to say how proud I am of this program in our district and all of the prosecutors who work on it every day, and in particular, the people who you have heard from today. Special shout out to Keith, John Boyle, Marissa Albaugh, and our support people who are helping them in the office do all of these things. It is a passion project for us, and we are very proud to have played not even intentionally, but a huge role in the formation of the law in the United States related to domestic abusers in the federal system, and to have gotten the word out that we as a federal system will be prosecuting domestic abusers. I will say on that note that one of the great things about prosecuting people who are really violent in the federal system is that we do not have parole. That is not a thing that happens in the federal system. So when Ted was talking about his defendant got 10 years, he was sent back to prison for 10 years, that man will be serving almost that entire sentence. There's a little bit of time you can get in terms of good time credit, but it's very minimal. So when he gets a 10-year sentence, he'll be serving virtually 10 years. So we can incapacitate people in a way that oftentimes the state cannot, because they have different laws relating to how quickly someone needs to be released. So we're very proud of the part that we play in the world that you live in, but we also are very thankful for everything that you do for domestic violence victims every single day, because you're on the front lines. We're just kind of carrying up the back. So thank you for everything you do. And if we can ever be of any service, please contact my office. Please contact the people that you've seen the email addresses for, or just call the main number and ask to talk to Keith or Marissa.
So we've come to the close of our time together. I would invite all the presenters to turn their cameras on so folks can see in the audience that we're all present. I can only speak for the domestic violence advocacy community, but I just want to extend a sincere gratitude. We are leaving this meeting with more knowledge, better equipped, but even more importantly, oftentimes we feel like we're carrying the weight of the world on our own shoulders. And it was clear today that weight is shared and distributed by many people who care deeply for this work and for creating a safer and just community. I often reflect on my experiences when I'm talking to survivors, and there is one person in particular that her words resonate with me deeply almost on a daily basis. Laura White was shot point blank by her husband with a shotgun, had a less than 2% chance of survival. And when we issue our Honoring Texas Victims report, we document each one of those 205 cases that we referenced. And Laura said to me, if you ever want to know what one of the victims on your report was thinking right before their life ended, I can tell you. And so with that, it drives the commitment to create that safety for every Texan. So Leah, Keith, Todd, Jonathan, and Tabitha, by the way, you make me so dang proud for representing TCFV on this webinar. Thank you for the work that you do. Thank you for helping make Texas a safer state.